the 10-minute rule motion, Suella Fernandes.
Mr. Speaker, I beg to move that leave be given for me to bring a bill to make provision for the enforcement of child arrangement orders, to establish a rebuttable presumption of shared parenting under such orders, and to make a provision for a commission to review and make recommendations on the operation of family law. David and Sally separated after 10 years of marriage in September 2014. They had 2 children, aged 8 and 5 at the time. David was a good father who did not want to stop being a dad just because his marriage had ended. However, nearly 3 years later, and more than £200,000 paid in legal fees, David is still fighting through the complex and bureaucratic family courts to see his children 8 nights a month instead of the 6 nights originally offered by Sally. Sadly, Mr. Speaker, this is not a fictional story. It's one of the many sad cases of high-conflict divorce. Family breakdown is painful for all involved, and it is the state's duty to support those going through this difficult experience. However, as in the case of David and Sally, not only have those 2 extra nights per month been financially and emotionally expensive for them, but on several occasions, Sally unlawfully stopped the children from seeing David, breaking the court order and undermining the father-child relationship. Mr. Speaker, Madam Deputy Speaker, child arrangement orders are made by the court to regulate the contact and residence of children upon divorce. In the majority of divorces, they are complied with, but in many cases, a defaulting parent, who could be the mother or the father, can generally act with impunity. The courts are slow to respond and reluctant to penalise, sending a damaging message that court orders are optional, not mandatory, that the relationship with the non-resident parent is meaningless rather than crucial, and that the system is inherently inequitable rather than robust. In the worst cases, a non-resident parent, usually the father, can be denied contact with his child for several years. If they don't have a spare £10,000 to spend on legal fees, they are essentially erased out of their child's life with no remedy whatsoever. How can this be humane for a child? How can it be fair to the parent? Yes, the welfare of the child is paramount, an abiding and unassailable principle of family law, and children are less likely to experience depression, teenage pregnancy and delinquency when relationships with both parents are safeguarded. Children without a father in their life often struggle to reach their full potential, academically, socially and professionally. But the law does not reflect this because of a failure to crack down on intransigent parents and judges and social workers who turn a blind eye to parental alienation. Madam Deputy Speaker, family courts make huge and life-changing decisions for parents and children, often on thresholds of proof that are far lower than those required to achieve enforcement. No wonder the criminal threshold for contempt is rarely met, and judges fail to assert their authority swiftly under the 1989 Children Act or subsequent legislation in 2006 or 2014. Attempts to bolster enforcement have not worked. Data from the Ministry of Justice reveals that in 2015, of the 4,654 enforcement applications, a mere 1.2% were successful. So although the letter of the law sets out discretionary penalties for breach, they are rarely applied in practice. And the rise in unfounded allegations of domestic violence as a defence to enforcement is worrying. A new approach is needed. A tougher 3 strikes approach where residents should be transferred if safe and community service is actually not theoretically imposed upon parents in breach is overdue. Confiscation of driving licences or passports should seriously be considered by Parliament. So legislation that emphasises the importance of both parents in children's lives, other than in cases of violence, is needed in England and Wales. Real enforcement is one way of doing this. Shared parenting is another. Madam Deputy Speaker, a rebuttable presumption of shared parenting should be a key principle when determining the contact and residence of the children. To be clear, this would not be an explicit statement of an equal 50-50 time division, and it does not mean shared care. As Professor Patrick Parkinson, the former president of the International Society of Family Law, has made clear, it should, as a minimum, mean the child's right to a meaningful relationship with both parents as far as practicable, and as long as the safety of the child is not put at risk. This is commonplace around the world and operates without difficulty. It could assure the child the opportunity for the maximum continuing physical and emotional contact with both parents, to encourage the parents to share the rights and responsibilities of raising the child, as the law states in Iowa, or it could provide for frequent and continuing contact with both parents, as in California. It could go even further to encourage the love, affection and contact between the children and parents, as in Colorado. Any of these examples, Madam Deputy Speaker, would be a more appropriate starting point for judges when setting child arrangement orders, not the weaker form of parental involvement, direct or indirect, currently on the statute book since 2014. Whilst that was an improvement on the previous position, parental involvement can amount to a birthday card or a Christmas card in the worst cases. Non-resident parents, mainly fathers, can be airbrushed out of the lives of their children by the current system. We can't keep telling fathers that they have equal responsibilities and then not give them equal opportunity to carry them out. Shared parenting and robust enforcement form part of a package of reforms that are needed if we are to bring our family law into the 21st century, Madam Deputy Speaker. Our antiquated system reflects norms of the 1950s and 60s rather than relationships of today, and many issues remain unresolved, leaving gaps for Parliament to fill. A commission, to last no more than 1 year, should be launched by the government to inquire into the following issues and report back with recommendations for reform. Firstly, as last week's Court of Appeal case of Owens depressingly highlighted, England's fault-based divorce law results in absurd outcomes. Despite being in a loveless marriage, the petitioner was unable to divorce her husband because of the archaic rules requiring her to prove fault on his part. The reality is that not all marriages end because of fault. We therefore have a law which promotes the farce of allocating blame, setting the parties on a needless confrontational path, fueling animosity and costs. A commission should report on whether it is now time for no-fault divorce. Secondly, financial remedies and maintenance are rooted in a bygone era where women were entirely financially dependent on their husbands. The reality today is that many women are able to support themselves, and so divorce should not mean an automatic entitlement to lifetime support from an ex-husband. Scotland and North America limit payments. Why don't we? Unless the noble Baroness Deitch's bill on this subject secures royal assent, a commission should make recommendations on how to strike a better balance so that England can shed its reputation as the divorce capital of the world. Thirdly, cohabiting couples with children are the fastest growing type of family in the UK. Between 1996 and 2016, the number of couples in this position increased from 1.5 million to 3.3 million, yet they have no rights in the event of a split. Inquiry into what basic protections are justified would be valuable. Fourth, the enforceability of prenuptial agreements should be set out by Parliament. If we are to support marriage, we need to accept that people are getting married later in life, with assets earned before and during their union. Those should be protected if the parties agree, not put at risk, and a commission should inquire into this. Fifth, reform of the opaque way in which the family courts operate in public law needs wholesale review. Far too many children are taken into care for wholly inadequate or poorly argued reasons. That's according to Sir James Mumby, President of the Family Division. Only the glare of publicity will enable this to stop, so we need to remove the cloak of secrecy and open up our family courts. And lastly, most family disputes need not see the inside of a courtroom, but instead need better incentive to use mediation or solicitor negotiation, for example, by virtue of a cost penalty for parties who draw out the process if appropriate. Saving costs, time and heartache should be priorities. Madam Deputy Speaker, I am not married. And it won't surprise you, therefore, when I say I don't have the battle scars of having lived through a nasty divorce. My views are informed by my previous work as a barrister in the civil justice system for 10 years, but moreover I speak today as an objective onlooker, moved by stories of injustice, hopelessness and deep sorrow. Yes, divorce is traumatic, but it need not be a tragedy that befalls thousands of non-resident parents. I hope the government will take this opportunity to begin the work of creating a family law system fit for the 21st century.
The question is that the honourable member have leave to bring in the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Who will prepare and bring in the bill?
Mrs Cheryl Gillen, Andrew Selous, Tim Loughton, Robert Neal, Frank Field, Caroline Ansell, Mrs Anne-Marie Trevelyan, Lucy Allen, Mr David Burrows, Kate Hoey, Mr David Lammy and myself.
Suella Fernandes.
Thank you. Family Justice Bill.
Second reading what day?
12th of May 2017.
12th of May 2017. Neighbourhood Planning Bill Programme number 3.